And welcome back. We are now speaking with Dr. Scott Gerber of Ohio Northern University, and today we're going to be talking about the equal rights. And there was a vote on an amendment that recently came up, and well, I guess you can just kind of walk us through exactly what happened here, Scott.
Yeah, so earlier this year, for the first time since the 1980s, the Senate held hearings on the ERA, and there was a resolution requesting that the deadline for ratification be waived so that the 38th state that ratified it, Virginia, so that would count and the ERA would be part of the Constitution. But last week, the Senate voted 51 to 47 not to do that. And so now, as before, there is no equal rights amendment to the Constitution.
So I guess the question is, where do we go from here?
Yeah, there's two options. One is just start over, and two is Senator Schumer, who's the Democratic majority leader in the Senate, made a procedural move that will allow the vote to be made again in the Senate to hopefully change minds on this, because I wrote an op-ed in March, which was Women's History Month, and I'm not on the left, but I think it's obvious that there should be an equal rights amendment because people are people and women deserve to be treated equally under the law. It's not complicated to me.
Yeah, this debate has been going on for a very, very long time. Now, of course, this isn't really a part of it, but now we're getting into the transgender situation where men are becoming women and women are becoming men. And if you go for equal rights, is this going to be a full-scale across-the-board equal rights amendment?
That, of course, would be up to decisions by eventually, I'm sure, the U.S. Supreme Court. But when reviewing federal anti-discrimination statutes 3 or 4 years ago, the Supreme Court read gender very broadly to include, for example, sexual orientation. So based on that sort of precedent, my guess is that a constitutional provision about gender equality could be read that way as well. But I'm not sure about that. It's complicated.
Yeah, it's a very complicated situation. I know we've seen some swimming organizations that have said, well, if you were born a male and you have recently transitioned to a female, you cannot swim and race against women because you're not on equal playing grounds, but yet this could all turn into a muddled mess.
Yeah, it's complicated. There's, you know, I'm not a biologist or a medical doctor, and so there are physiological differences there that, you know, most likely factor into athletic performance. I think that's the argument against allowing transgender individuals to compete in women's sports. But what I'm talking about in the op-ed is just the basic equal rights amendment that was first presented 100 years ago, and that has been ratified by 38 states, which is the magic number, but one of them was a bit too late. And I'll also point out that almost every country in the world has a constitutional right for women of equality, and most states do as well. So it affects how the court interprets statutes. As I pointed out in the op-ed, statutes that treat people differently on the basis of gender are reviewed less closely by the courts than are statutes that treat people differently on the basis of race. And my argument is people are people, and people should be judged as individuals, not as members of any particular group, gender, race, ethnicity, etc.
Well, this debate could certainly go on for hours, but Scott, we thank you for your time this morning, and we will be back with more right after this.